Good morning, everyone. This is For the Record with Greenwood Law. I'm attorney Harold Eustache, along with attorney Dylan Greenwood, and today we have a very special guest with us today. This is Professor Shannon Gilreath. Shannon Gilreath is a constitutional law professor at Wake Forest University. He was a professor that I studied under, and we're very, very happy to have him here today to talk about
It's
the
my
First
pleasure
Amendment.
to be here.
Yeah, so we're going to be talking about the First Amendment today, and obviously the First Amendment has gotten quite a bit of press recently, as it typically seems like a certain cycle of things happens that the First Amendment gets brought up from time to time, and obviously most recently it's come up especially with social media and social media rights, what can and cannot be said, whether or not social media can ban certain people from time to time, and that sort of thing. And I know that when individuals use social media, obviously you have to sign up, and typically you consent to some sort of terms of agreement for your consensual use of their platform. And of course, we all read that fine print, right?
Of course.
Yeah, even as lawyers,
Yes,
we
very
read
diligent about it.
every single word. But in a lot of those terms and conditions of use, there is a section on whether or not the First Amendment, as the social media platform sees it, applies to them. And I know Twitter very specifically has the stance that they're a private company, and because they're a private company, they can do as they wish and regulate their platform how they wish. But a lot of people have invoked the First Amendment as it pertains to social media, and might have a different stance on that. So that's what we're here to discuss today.
We are, and in that same vein, when they hear that certain people or certain voices are censored by Twitter or Facebook or YouTube or Google or whoever, they say, well, freedom of speech or First Amendment. And so what does that mean when somebody says that, Professor Gilreath? What are they accurate there?
What does it mean when they talk about the First Amendment in the frame of private companies?
Right.
Well, I think it means that a great many people have yet to realize that the Constitution is a piece of paper with words on it. And they can go read what it actually says. The First Amendment literally begins with the word Congress, right? Congress shall make no law abridging the freedom of speech. And so it's simply inaccurate to talk about First Amendment guarantees constitutionally when the censor is, it is censorship. It's just not constitutionally it's not unconstitutional censorship, because the government is not involved in making the choices about what viewpoints are permitted and what viewpoints are impermissible. Where a private corporation does that, it's the same as you saying, Professor, I don't like something you're saying in my office, get out, right? You have the right to do that because it's you are the master of your domain, so to speak. And so are these companies that are primarily there to make money. They're not there to facilitate people's political speech or any other kind.
Well, and I think this debate is so interesting because we have different cases that have come out, and a lot of these cases on First Amendment, as they get viewed by the Supreme Court of the United States, a lot of them kind of are value judgments. It seems like based off of the what it is, the entity involved, and what the actual speech is. For instance, some people take the view that all speech should just freely be allowed. Well, if that were the case, then the government couldn't regulate child pornography, and the government couldn't regulate the fact that you shouldn't be able to communicate threats to other people. There's certain speech that we as a society have said, okay, there's this right to have speech, and the government shouldn't regulate it, except there are these avenues or these things that we have said, hey, no, this isn't good. The government has this right to step in.
Right. Well, and those things are legion. I mean, you mentioned communicating threats as an example, but it's much more basic than that. The freedom of speech is like a sieve. You know, almost everything runs through it as an exception, not as something caught right in the protections of the First Amendment. So basic contract law, right, implicates speech. I can't say to you, Dylan, would you mow my lawn for $5? And you accept, right, and come mow my lawn, and then I say, oh well, I was just exercising my right to free speech, but I didn't mean it. I'm not giving everything. The law is itself one enormous exception to this sort of free speech absolutism that people seem to believe exists in the United States, and really the opposite is true. It's a question of the exceptions, right, as opposed to, or I suppose it would probably be clearer to say it's a question of what's included as opposed to what's accepted, because the exceptional category is much larger than the category that's actually included in First Amendment protection.
Right.
Why do you think it is that people believe that there's this sort of universal free speech in the United States? I mean, because we hear it so often that people invoke that.
Well, I think it's just part of the cultural zeitgeist, you know. I mean, there is this view that freedom of speech is nearly sacrosanct, and that it's ever present, and everybody has it all the time, no matter where they are, right? We just have a right to say what we want to say when we want to say. That isn't true if you look at the jurisprudence, but it is a sort of overriding American myth. And we are far more speech protective than other Western democracies about some kinds of speech, hate speech, that sort of thing. In England or Germany, for example, where Nazi symbolism is literally illegal, right? You can be subject to sanction for wearing it or circulating it. That could never happen here. So there is, there is a sort of umbrella of free speech that is unique in the United States, but that umbrella doesn't shade a great deal of ground, right? And people seem to think that shadow is cast much farther than it actually is. And so really, that sort of core component of First Amendment protection of speech is dealing with political speech, and the doctrine is essentially that the government cannot engage in viewpoint discrimination. And when you narrow the category to that, right, while it's important to our democracy, although not without its, the court's current stance is not without its problems, but it's an important category, but it is far smaller than people seem to think it is.
A lot of people have a viewpoint when it comes to freedom of speech that it is one of potentially the checks and balances of our government. That by citizens being able to engage in an exchange of ideas, or being able to disseminate certain things in the press about what's going on with the government or whatever else, that it almost serves as this fourth check and balance that isn't set in stone by the Constitution that you have with all these the other forms of government, but it's kind of the one that we as a public have. I always found that to be an interesting viewpoint when you take into account that the same people who drafted the First Amendment are also the same people who drafted the Alienation Sedition Act, which that act basically said that if you speak bad about the government, we're going to lock you up and throw away the key. And that act was never judicially reviewed, and I don't think it was ever really formally repealed.
Just sort of faded away,
right?
Well, I mean, Nat Hentoff wrote a book called Free Speech for Me and Not for Thee. And that's sort of been the American view from the beginning, right? I mean, people claim the right to speak freely, but can have a very different reaction when they're faced with, ideas with which they vehemently disagree. And that, by the way, is not that's not reserved to one side of the political aisle or another. I mean, if you think there isn't a great deal of liberal police work done on what people can say, then you haven't spent 15 seconds inside the American Academy. I'll tell you that much. But I think there is an idea that, or there was in the founding generation, that it was important to give some independence to the media. Mm-hmm. Because, of course, they were rebelling against the English government, the government of the British Empire, which really did have a stranglehold on the dissemination of information right to the pulpit, right? And so you see in the First Amendment a reaction to all of those things that the founding generation thought had kept what they viewed as despotism in place. And so, the First Amendment deals with this sort of disparate array of institutions that are geared toward free thought. So you have freedom of religion, you have freedom of speech, and of course you also have singled out freedom of the press. Mm-hmm. Now, I think that's a fine idea, and it's a perfectly 18th century idea. Mm-hmm. I sometimes wonder if we shouldn't now be talking about freedom from the media as opposed to freedom of the press, because the founders, I think, could not have foreseen this era where Facebook, Twitter, these enormous social media platforms have allowed people with nearly no knowledge and usually less wit to sort of sally forth into these extraordinarily complex issues and mislead as often as they inform. Mm-hmm. I mean, there is such a thing as a lie. And I think that concept has sort of been lost somewhere in current American political discourse. But there is a great deal of dissemination of false information, totally, or sort of a trade in half-truths. Mm-hmm. So I tell you just enough, right, to convince you that I'm right about something, right, but I don't tell you the whole truth so that you can make up your mind for yourself, which was really what the founders were interested in, right? They were interested in people getting legitimate information and being able to make informed decisions about how their government worked.
And having a discourse back and forth, where through that discourse, that's really how democracy can and should work. What you mentioned with Facebook and Twitter and all these other social media things, and there are good things about social media, sure, don't get me wrong. There are people that I stay connected to that I probably would have never been able to before.
Oh, yes, that's true.
But it is so easy to choose and to narrowly tailor who you are in groups with. You can literally group yourself up. You can block certain people so that you never have to hear from them again. You can really funnel and filter out all the information that ever comes to you, that it only comes from basically one source or one type of communication or one type of viewpoint. And that is what is so fraught with peril.
It's the echo chamber effect. And so rather than the government controlling the noise in the chamber, it's other non-government actors doing it, and yet they're serving the same function, right? They're keeping a lid on the dissemination of the whole picture of information. And I don't think it's necessary to make a judgment call about which is worse, right? Whether the government's doing that or whether independent actors with certain political goals are doing it. Either way, what's fairly clear is that this is not the vision the founders had when they were thinking about freedom of speech and freedom of press and the interplay with that and a strong functioning democracy.
Okay. So I know that we've established that the First Amendment applies to the government and Congress. But are there instances in which Facebook or Twitter or private companies could violate the Constitution in some way when they do suppress different types of speech?
Well, I mean, yes, but really probably more in theory than in fact in terms of legal reality. The Federal Communications Decency Act does have these provisions that deal with imposition of liability for news outlets, news platforms, when they are removing content or censoring it in ways that violate FCC rules. But for the most part, those rules actually expand the legal protections to these kinds of companies far beyond what you or I would enjoy as individual citizens. So, for example, in North Carolina, if I repeat a defamatory statement about a person, even though I didn't originate it, simply because I circulated it, I can be liable for defamation. That's not true of media platforms under the Federal Communications Act. They are immune from that liability, even though they magnified. I mean, that's what we see so much now, right? What I call the social media drive-by, right? Where somebody posts 30 seconds of a police confrontation or something, and that goes to millions of people, and it's actually a completely wrong picture of what happened in the context of the entire encounter. But in the meanwhile, this sort of mob has assembled across across the internet, demanding that this person's, that they lose their job, that and so on down the line, and so the media platforms being insulated from liability for that ensures that they make no real effort, right, to protect people from that kind of, I don't know, what do you call it, vigilantism via the internet.
Yeah, and what makes that even more concerning is, used to that mob would take hours or days to create. On the internet, it's instant.
Yes, it's instant, and it's also now in an electronic age, life-threatening in some circumstances, right? Because people know where you live, they know, what school your children are in. All this stuff is, at the touch of a keyboard, and I think it's quite dangerous. And I think the law is wrong-headed on it. But I don't see, at least in the very immediate near term, I don't see it changing in that respect. So, I mean, to Harold's question, I think it's sort of exactly the opposite, right? That the law, as such as it is, actually expands the immunity that these companies enjoy, rather than imposing any liability for them infringing on people's expression.
Thank you for joining us here on WTOB. This is For the Record with Greenwood Law. This morning we've got a very special guest, Professor Shannon Gilreath from the Wake Forest School of Law. Both Harold and I went, and we've got Harold Eustache here today as well. And we're here talking about issues with the First Amendment, social media. It's been hotly debated here lately because of some things that have happened, specifically with the banning of a very famous Twitter account. And although we've discussed here today that Twitter doesn't necessarily implicate something with the First Amendment, beyond that, there could possibly be other First Amendment issues here, right?
Yeah, and that's what we want to ask you is, I know, everything sort of underlying this was about whether former president's speech did violate the First Amendment in some way, and as opposed to whether Twitter violated the First Amendment. So is there an actual First Amendment issue here that we're not seeing?
Well, I think the part of the whole drama that what a week of Wednesdays we've sort of had, right? We had a sort of assault on the U.S. Capitol. We had a president, first in history to be impeached twice, So that the assault on the Capitol is a Wednesday, the impeachment is a Wednesday, and then we have inauguration of a new president on a Wednesday. It's been quite a month of Wednesdays.
That's America.
Yeah, really, anything. But the backstory to the Twitter Trump feud is really this question of whether things that he said on Twitter and also in person to this crowd of people incited those people to storm the Capitol building in an illegal way. And although people, really aren't pinpointing the First Amendment dimension of this in that spot, they're much more concerned about whether Twitter can revoke his right to post things. That's really where the heart of the First Amendment controversy is. There is a case called Brandenburg against Ohio, which involved a Klan meeting, and the leader of this meeting saying, I think the quote was, if the government doesn't do something about these uppity, insert your marginalized group there, right? Because he was talking about not only blacks but Jews and homosexuals. That we may have to take vengeance on them, right? And or actually, I think he said revengeance, right? Not necessarily the brightest bulb in the chandelier. So the question was whether the sheriff, having arrested him under an incitement statute, could survive the First Amendment, right? So the Klan leader invokes his right to speak under the First Amendment. The sheriff says, "Well, I have my incitement legislation," and who wins, right, in this struggle? Well, the U.S. Supreme Court says in Brandenburg that where you're dealing with a case of incitement to imminent lawless action, the speaker must be allowed to speak. First Amendment protections attach to that speech, unless the government can prove that it was the speaker's intent to incite imminent lawless action, and the audience to which the address is made is likely to perceive it as such and to act on it, right? I mean, that's implicit, right? If there's no action, then there's no imminence, right? So that's a fairly speech protective standard on one hand, because there's these sort of triple insulators for the speaker. So the question with regard to President Trump is whether he intended to incite imminent lawless action through what he said, and whether the people hearing him understood him to be doing so and were likely to undertake that lawless action.
Seems like the first part of that standard might be difficult to prove.
It would certainly be the sort of thing prosecutor and defense would there'd be a good show, right? If you were in court that day, there'd be a good show at the trial court level. So that would be if there were to be a prosecution of Trump under some statute for what happened at the Capitol. That would be the test, right? Brandenburg would be the First Amendment law applicable in this situation.
Gotcha.
Now, it's worth pointing out to your audience that sounds like a very robust speech protection. But when you sort of scratch the surface, what you see is the court is saying people are protected. They have robust protection of speech up until the point that they are actually likely to convince somebody by their speech to do something. Well, it could be true that in the social media age, most people are just talking to hear themselves talk, right? But where we're talking about political speech, the motivation is always, right, to galvanize other people to your cause. So Brandenburg is really a standard that says, particularly where anti-government activity is concerned, that there is sort of broad protection of that speech up to the point where you're actually likely to get people to do it. And at that point, the government can tamp down And so when you look at it from that vantage point, if you are, right, a disgruntled person, that isn't very protective of your right to political speech. And certainly not in the context of a country that is, literally born of a rebellion, right, against its former government. So it's a sort of interesting history, right, to watch the court grapple with this question of First Amendment free speech protections, and also the understanding that the government has to be able to resist insurrection. And the court, trying to move the line to exactly the right calibration.
Sort of a little bit before, and how these laws on insurrection and sedition, many of them written a long time ago, they are very, very broad in these statutes. And I was just reading the North Carolina statute before this discussion, and then, wow, it's encompassing quite a bit of language or behavior that could be deemed as sedition or insurrection. Those laws haven't really been challenged much, but it is interesting that because we have a nation that was born out of this sort of sedition, in a sense, that the framers seem to be very, very keen to what language would and wouldn't be sedition, considering they just did it.
Yes, and they were responding to their time, which was a time of real risk. I mean, stitching together these sort of disparate confederation of former colonies, where the center of identity for the individual was very tied to the state, right? I mean, if a person traveling abroad in the 19th century even wouldn't, if asked where they were from, would never say, "Oh, I'm an American," right? They were a North Carolinian or a Georgian or a New Yorker, and so there were tremendous threats to the stability of the government in that sort of nascent period, and you do see the what looked to us like very draconian laws coming out of that period. But they were responding to very immediate threats to the stability of the U.S. government. And I suppose on the whole over time, I mean, I'm very happy to be an American and live in the U.S., which doesn't mean I don't think there are things about it to criticize. But I think the actions they took then on the whole were necessary. Whether that's necessary now is another question. And the fact that, as you note, so many of these laws about rebellion and sedition and insurrection are really sort of 19th century concepts. It may be time for a sort of rethinking of that paradigm. But I don't think that's high on many legislatures' lists, right? But you do point out that there's a great deal of incompatibility between those laws and sort of modern circumstances, I think.
I think it's interesting too, you mentioned in the Brandenburg Standard, as it applies to the speech that we've been talking about, that, there has to be speech kind of advocating this unlawful conduct. But then a second prong of it is that whether that speech was likely to incite or induce the unlawful conduct. And the FBI right now is very much tallying a large group of people that they may or may not be going after for some sort of prosecution.
Yes.
And, we've sat in on some FBI proffers in our time as defense attorneys. And if you start asking questions about why you did what you did, what prompted you to do it, if you get enough people in there that say, well, I saw what I felt like was a call to arms to go and do, what I did that day, those could be very interesting, pertinent statements.
Well, complicating things. I don't know if you saw the guy who was wearing the horns and the sheepskin.
I was going to buy Harold something.
Well, he'd look good in that, I think. Yeah. But or maybe with my 6 months of no haircut, I should be wearing the horned helmet right now. But that guy's lawyer, his defense is that he understood the president to be calling him to arms for the good of the country. So if you were Trump's lawyer, right, in a Brandenburg contest, you'd be going, oh, geez, this is somebody shut that guy up, right? Because that's very bad for the Brandenburg test, right? And I suspect you'll see a lot of defendants claiming that they believe they were, and many of them probably did believe, and that's to say nothing of Trump's mental state. I'm just saying that there were a lot of people who probably did think that they were responding to a bona fide attack on their democracy, and that this was the way to do it, and that it was coming from a source with greater knowledge and authority than them. And where Brandenburg is concerned, that makes defense much more difficult.
Thank you for joining us this Sunday for our discussion about the First Amendment and how it relates to social media. Professor Gilreath, thank you so much for being on the program with us this Sunday. You have been incredibly insightful, and I think you've added a great voice to this debate and understanding of just what First Amendment is and how it applies. Our big thing on this show is knowledge of your rights. Know your rights. That way you can assert your rights, all the things that are afforded to you by being in this country. And so thank you so much for providing that insight.
Well, thank you. It's a great civics program. So thank you for inviting me.
We do what we can. And don't forget to join us next Sunday as we kind of continue along this path. And we're going to be talking about Miranda, and not Sex and the City Miranda, but Miranda Warnings and how that applies to you and Fifth Amendment rights. We get calls all the time, don't we, Harold?
A lot.
People tell us, well, the officer never told me my Miranda rights. Well, they may not have had to. So we're going to get into a discussion of every bit of that. But before we go, don't forget that Greenwood Law Bill of Rights.
The first thing, I will not represent myself in court. I will not do law enforcement's job for them. I will not make statements when stopped by law enforcement. I will not consent to searches when asked by law enforcement. And I will not be my own star witness for the prosecution. Remember, everyone, that it's not a crime to know and assert your rights. Stay informed. Stay safe. This is For the Record with Greenwood Law, signing off.